Tyler Reddick and Bubba Wallace would be free agents today if 23XI and Front Row's injunction request had not been granted. Let's dive deeper into yesterday's legal decision. How's it going, y'all? My name is Eric. Welcome to Out of the Groove. Yesterday, one of the biggest stories of the NASCAR offseason broke. Today is going to be a follow-up to that video. But first, there was some sad news yesterday. NASCAR Hall of Famer Fred Lorenzen sadly passed away at age 89. A star in his era, a Daytona 500 champion, one of the greats of stock car racing's past. I'll link a short NASCAR.com piece down in the description below. Obviously, it covered many of Lorenzen's accomplishments if you aren't familiar with the driver, but it also went into surprisingly good detail, so I'll link that down in the description below. It's always a sad day when a legend of NASCAR passes. Fred Lorenzen, NASCAR Hall of Famer, all-time great. Wanted to begin the show with that. Before we get into the latest legal stuff, Legacy Motor Club unveiled a new logo this morning. Might as well. They've changed pretty much everything else. Just a subtle difference. I like the wings, I guess, they've added. Not too different from the current logo, but I like it. Legacy Motor Club needs a reset after a disappointing 2024. They need to start having fun over there. Oh, not sure if this was the fun I was talking about. What is going on here? Anyway, yes, new logo for Legacy Motor Club. Yesterday, we discussed broadly the big picture ramifications of 23XI Racing and Front Row Motorsports being granted their preliminary injunction request. They've acquired charters for 2025 and, in my opinion, have been granted the financial security they need to continue fighting NASCAR in court, which then potentially puts pressure on NASCAR to reach a solution sooner rather than later. Today, I want to examine more of the specifics of yesterday's ruling. Why were the teams granted a preliminary injunction? What was the immediate irreparable harm they were able to argue? Much of the decision yesterday focused on the legality of the release language in NASCAR's 2025 charter agreement. Judge Kenneth Bell wrote that the release language, the "you can't sue us" clause in the charter agreement, likely does violate antitrust law. He wrote, quote, "Plaintiffs," that's the teams, "have established that they are likely to succeed on their claims that 1. NASCAR has monopoly power in the market for premier stock car racing, and to the extent that NASCAR's 2025 charter agreement includes a release that bars teams from asserting the antitrust claims asserted by plaintiffs, such a provision would be a violation of the antitrust laws." If that wasn't clear enough, Judge Kenneth Bell continues, "In practical effect, the question before the court is, can a monopolist require that a party agree to release the monopolist from all claims that it is violating the antitrust laws as a condition of doing business? The answer is no." Basically, the judge is saying, yes, NASCAR, in their opinion, has monopoly power, and the "you can't sue us" clause in the charter agreement is likely an abuse of that monopoly power. First things first, obviously this is just the opinion of a single federal judge, but it makes you wonder if any of the other 13 chartered teams would consider joining this lawsuit. This judge basically threw out NASCAR's "you can't sue us" clause, said, hey, that's arguably illegal, that's unenforceable. Those 13 other teams that signed the agreement may see that and say, okay, well, shoot, maybe we'll attach ourselves to this lawsuit. Because think about it. If NASCAR is truly feeling as much pressure now as I think they may be, they're going to go back to the negotiating table at some point, talk with 23XI and Front Row. If you're a team sitting on the outside, you don't want those two teams to potentially negotiate more favorable terms, whatever terms they hypothetically could agree to. Maybe NASCAR would broadly apply them to all 15 chartered organizations, but maybe not. So if you're a team on the outside, like say a Richard Childress Racing, and Richard Childress has said that he felt forced into signing this agreement, you may decide to join the lawsuit battle alongside 23XI and Front Row, because this judge just said the "you can't sue us" clause is unenforceable. You're not risking much. 23XI and Front Row just proved that. So that's where my head goes. This is all hypothetical, of course, but based on yesterday's ruling, could any of these other Cup Series teams join the fight alongside 23XI and Front Row? I think it's certainly possible that this whole legal case becomes bigger before any resolution is settled. Anyway, that was just one part of yesterday's ruling. So remember, 23XI and Front Row Motorsports, in order to have their injunction request granted, they still needed to prove that they were at risk of suffering immediate irreparable harm. Sure, NASCAR left the release language in the charter agreement, but they removed it from the open agreement. So 23XI and Front Row could have raced next season as open teams. You don't need a charter to race full-time and contend for a championship in the NASCAR Cup Series, so the teams not only had to convince this judge that NASCAR was bending antitrust laws, but they also had to convince the judge that without this injunction being granted, they were at risk of suffering immediate, immeasurable harm. Back in November, the team's first preliminary injunction request failed because they failed to show immediate irreparable harm. Instead, the judge said their claims were too speculative, hypothetical. The teams might lose sponsors, they might lose money, they might lose drivers. To counter that, this time around, the teams, in my opinion, employed a very clever strategy. See, most of 23XI and Front Row's driver contracts require that the teams provide a chartered car. Again, having a charter guarantees entry into every single cup race, guarantees larger payouts, allows the teams to be more financially stable. We found out last month that Tyler Reddick would be allowed to opt out of his 23XI contract if they could not provide him a chartered car. This is how the teams were able to convince Judge Kenneth Bell they were in danger of suffering immediate harm. Judge Bell writes in his statement, quote, "Since the court denied the initial motion, 23XI's top 2024 driver Tyler Reddick has given notice that the team is in breach of his driver contract, which will allow him to leave the team if the breach is not cured in 30 days. The deadline was yesterday, December 18th. Drivers Riley Herbst, Noah Gragson, Bubba Wallace, and Corey Heim have similar contracts and/or have expressed their need for immediate resolution of the uncertainty surrounding the approaching racing season. The lack of chartered cars has also impacted plaintiffs' sponsor relationships, specifically with key sponsors Monster Energy and Love's Travel Stops. These are changed circumstances that the court finds have moved plaintiffs' likely harm from remote and speculative to present and immediate." I read the full documents. Yeah, Love's apparently sent emails to Front Row Motorsports expressing concern. That passage is super interesting. Well played, 23XI and Front Row. Well played. I don't know this for a fact, but I'm skeptical Tyler Reddick was actually going to leave 23XI racing this offseason, even without a charter. Like, where else is he going to go? What other championship contending team has an opening right now? The answer is none. I guess, hypothetically, a team with a driver on an expiring contract could have jumped through some hoops, pulled some strings, and bought that deal out to go get Reddick. I guess that's possible, but I think it's unlikely Reddick was going to leave the team. And actually, Judge Kenneth Bell writes about that in these documents. He wrote, "Defendants," that's NASCAR, "suggest that plaintiffs' drivers' concerns are insincere and they won't really leave the plaintiffs' teams. While the court, of course, can't completely discount that possibility, the reality of the situation for both the drivers and the plaintiffs is clear and immediate. Absent entry of a preliminary injunction by December 18th, Tyler Reddick will become a free agent, and whether or not he has a firm plan to leave 23XI, other teams will have the present ability to contract for his services. While irreparable harm cannot be speculative, it need not be certain or have already occurred before an injunction is granted." So maybe the drivers were serious about exploring other opportunities, maybe they weren't. It really doesn't matter. The sponsor concerns, I believe, are very, very real. Either way, these concerns ultimately compelled the judge to grant their preliminary injunction request. Well played by the teams. Imagine if right now Tyler Reddick was a free agent. How would that work? Again, there are no competitive Cup Series seats currently available, but Someone could get bought out. Who's on an expiring contract? Probably like half the garage. No one at Hendrick. Not even Bowman. I see you all saying 48, put him in the 48. Bowman's got 2 years left on his deal. Ally loves him. I don't think that would happen. I don't know. Who's on an expiring contract? Nobody at Penske going anywhere, I wouldn't think. Same with JGR. I mean, Chase Briscoe just got there. It would be a real bad PR move to kick him out of the 19 before he's even made a lap. So yeah, I don't believe there are any better opportunities than 23XI Racing readily available. So yeah, I don't know. Maybe they were bluffing, maybe they weren't. Either way, it's interesting to discuss. I'll end with this. Yesterday, the judge was mainly focused on the merits of the team's injunction arguments. He wasn't there to judge the merits of the broader antitrust case, though he did weigh in here and there, not necessarily picking a side officially. He's not making a decision on the broader antitrust case at this stage, but I do find it interesting he wrote multiple times that he believes NASCAR possesses monopoly power. This short passage in particular, Judge Bell writes, "The court finds that NASCAR possesses monopoly/monopsony power in the relevant market, which is the market for premier stock car racing teams in the United States. Therefore, NASCAR fully controls which race teams can compete at the highest level of stock car racing. Effectively, it has 100% market share." Again, that's just one judge's opinion. Doesn't necessarily have any bearing on the broader antitrust case. It just goes back to what I said yesterday. NASCAR, maybe for the first time in this whole 2+ year process, is feeling real pressure. They no longer have the most leverage. The injunction ruling literally could not have gone any better for 23XI and Front Row Motorsports. I mean, it's been nearly 24 hours and we still don't have a statement or a response from NASCAR or their attorneys. I wouldn't be surprised if they're scrambling a little bit, if they're back to the drawing board, examining their next steps. Yesterday was a huge first step towards what could be a transformative moment in stock car racing's history. Thanks for watching this episode, folks. Let me know if there's anything you found particularly interesting from yesterday's ruling. Leave a comment down below. Leave a like while you're down there if you enjoyed the video. If you're new to the channel, we talk NASCAR almost every day, all year long. Subscribe so you don't miss any upcoming episodes. Big thank you to my Patreon supporters as well. I will talk to you again soon. Have a great rest of your day, folks. Thank you so much for watching.